Many people might think that modern legal systems are pretty much the same. However, on a closer look, just as the food eaten in England, Italy, and Israel is vastly different, so are their legal systems. In England, most cases are incentivized to settle before the filing stage, and judges see a very small percentage of cases. A full trial is usually too expensive for the average disputant. In Israel, cases reach court, and a pre-trial judge sees quite a lot of them, but only very few pass this stage to trial. The pre-trial judge takes a hands-on approach to the cases in the search for settlement. In Italy, most cases can reach court where they see a judge, and the judge can fit the form to the fuss. In other words, try to encourage the parties to settle, attempt mediation, or receive a judicial verdict. So the focus is different in each. In England, the focus of the legal system is on the pre-filing stage. In Israel, on the pre-trial stage, and in Italy, on the trial stage. This has far-reaching implications on access to justice and the centrality of judges in handling disputes. But just as you can find fast food, a burger and fries in any one of these countries, you can also find fast justice. Legal systems have been trying to make their processes efficient, creating fast tracks, and also sending cases to alternative justice, mediation, arbitration, and the like. However, a well-thought-out formula of when to prefer each mode of disposition is lacking. Mostly, and especially in common law systems, the general idea is that it's best to avoid a full trial, unless parties insist on doing so. So when is fast justice appropriate? When is full trial? When is alternative justice? And how much of this should be left to the choice of the disputant? That is something legal systems will be grappling with, at least we hope so, in the near future. The research shows that wholesale encouragement of alternatives to trial or fast justice waters down original legal principles, such as the defendant's protections in criminal justice. Today, parties reach court expecting a certain process, but get a shortened one or are directed to an alternative process. How many obstacles they meet if they prefer a full trial differs greatly between legal systems. Legal systems should keep in mind that, unlike food, which is good to have at least 3 times a day, legal proceedings are something no one really looks forward to. Thus, legal systems should be extra sensitive to the needs of individual litigants. Most of the time, individuals meet legal systems once or twice, and that is the impression they will carry with them for a lifetime. Making statistics on cases and alternatives available so that litigants know what to expect, enhancing judicial training to include soft practices, and ensuring that enough cases go to trial to allow for a supply of normative precedents are but a few policy recommendations resulting from the research, all with the aim to create responsive legal systems that cater to the individual litigant and have much richer principles than efficiency on their plate.